Good morning, everybody. It's a pleasure to be here. I think this is a fantastic opportunity to get together and talk about mental health. And I really appreciate seeing all the different stakeholders here who come to discuss this topic. I mean, this is usually the slide I put up when I'm talking to the general public about the situation, but it's redundant with you guys. You guys are all working in the criminal justice system, so you understand what's going on. You know that mental health is a huge issue when we're talking about our criminal justice system. Oh, guys. So we know about it, the public's knowing about it, but certainly the media has picked up on this. Everybody will tell you your county jail is your biggest mental health institution. I mean, that's just a fact. I remember when I grew up, we had the state school system. I grew up in Limestone County, a small county, and the Mejia State School was the biggest employer in the county. And spread throughout the state, there were tons of these state schools that dealt with mental health issues. However, through funding cuts and things like that, it quit being available, and so our jails took over. And we all know that our jails are now full of people coming in with a mental health issue. So, I want to have an opportunity to point out the great job that the Judicial Commission on Mental Health did with the bench book. If you haven't looked through it, this year's edition is fantastic. It's really user-friendly, and it's easy for you to see the different intercepts. And what do we mean when we say intercept? It's the opportunity to deal with someone who has a mental health issue. And what you just heard from Harris County, they were talking about their law enforcement intercept. In other words, an opportunity to divert someone from the criminal justice system or from jail by taking them to some kind of treatment facility. So what they were discussing is a law enforcement officer on the street who makes the decision not to take this person to jail, but instead to take them to some kind of treatment. But what about the other people? What about the people that don't qualify? As I told you, there are some offenses that the DA doesn't want diverted. Well, those people are going to get taken to jail. And those people still have a mental health issue, but they're now at the door of your jail. And everybody knows it's a lot easier to get into jail than to get out of jail. So what's the answer there? Let's do something different at the door of the jail. Let's make sure that that person doesn't get booked in. Because as I said, once you're booked in, once you're waiting on a court date, once you're waiting on your court-appointed attorney, once you're waiting on a judge, then it's too late because you could spend days or weeks in that jail cell. So what we were looking at in Bexar County, how can we stop that process at the door? Now, that front door of the jail is controlled by several statutes. And again, they're all discussed in the bench book. Now, Intercept 1, as I said, was what Harris County was talking about, what the law enforcement officer can do. Intercept 2, which is tabbed in the book, talks about that door of the jail. And these are all the different codes you'll read about. 1517. 1517 is just the statute that says you have to be taken before a magistrate within 48 hours of your arrest. And at that hearing, that magistrate will set your bond and will determine if there's probable cause to detain you. 1703 talks about what offenses you can get a personal bond for. Now, there are certain offenses that are disqualified. You can't get a personal bond, but the ones that are eligible are in there. 17032 is distinct to the mental health venue. 17032 says the magistrate shall order your release on a PR bond if you have a mental health issue and you have a treatment plan. And it says shall. So it takes away a lot of the discretion from the magistrate. So how do we divert those people? We have a treatment plan. We have a medical diagnosis of mental illness. Now, there are offenses that are disqualified. They're called violent offenses, and that's actually the term they use, which you can't get this bond. But for all other offenses, there's a provision under 17032 that gets you out of jail, that keeps you from going in there. And then, of course, 1622, which is now known as the Sandra Bland Act. Now, what's interesting is 17032, and frankly, some version of 1622, has been the law since the mid-90s in Texas. But really, nobody ever used it. Nobody ever knew about it. Nobody was doing anything with it. So, in about 2014, Bexar County said, well, let's do something about the front door. And we started working with the local mental health authority because they're going to be critical. And Bexar County formed the mental health department headed by Gilbert Gonzalez, who's with us today. And basically, they worked out a system so that we could start getting people assessed by a clinician from the moment they walk into the jail. Now, when we started in about 2014, there were about 11,000, 12,000 people who came in with mental health issues. And despite all this work we had done with the local mental health authority to provide clinicians at the jail and to talk to the magistrates, only 125 were diverted. And so when I got hired in 2015, they began to talk to me about this particular program. And some of the highlights of that program, again, through working with the local mental health authority, which has been critical, the Center for Healthcare Services in Bexar County, we were able to work out an agreement that people who we divert into treatment get to cut in the line, basically. The local mental health authority is required to provide treatment for persons with mental illnesses. The problem is there's a long wait in just about every county in the state, sometimes 9 to 12 months to get into that treatment. So what we did is we negotiated with the local mental health authority to allow the people that we have who are at magistration, who are going to be given this type of bond, could go immediately into treatment that day and cut in line. That's been the critical part of that program. But again, it wasn't being utilized. And so what was the problem? I think a lot of it was we didn't have everybody at the table. So what I proposed was let's provide counsel at magistration. Let's let the public defender's office have an attorney there to work on driving these people through the system. And it made a huge difference. I think the main thing it did was it brought all the stakeholders together. Because I know the Mental Health Authority was working on this with our mental health department, but the judges weren't really that involved in the process at that point. And of course, when we started talking about providing representation at magistration at this very first hearing, we had to approach the judges and get their permission, get their authority to represent these people. So that had to bring them into the conversation. It also brought the sheriff into the conversation because we were going to be located at the jail and we needed office space at the jail. And so it got him in the conversation. And of course, once we put a public defender there at the jail, the arresting agencies who were bringing people in would say, "Who are you and what are you doing here?" Well, we're trying to do these diversions. So basically, it got everybody talking about the program that we were doing. It also got the DA involved, and I think that was critical. Just as they were saying about Harris County, we started a conversation with the district attorney about, well, are there some of these people, some of these charges that you would agree to divert? And we developed a list, basically, of all the offenses that the district attorney would agree would be okay to divert. And what we saw was a huge increase in the diversions. Basically, prior to 2015, 125 people were diverted. For this year, we're on track to divert 630. So previously, we were doing about 2.4 a week. Now we're doing almost 2 a day. And what's the difference? I mean, the difference is it's becoming more known about what is available. In other words, the people that we are representing at magistration are getting treatment. And this has kind of been how we've talked to the public, because you'll hear this a lot, is public safety. But if someone is going to get out on bond, usually the number one determinant is what? Their financial means. I mean, if you have two people who have a $10,000 bond, a guy is going to get out if he has $1,000. Well, what if that person needs mental health treatment? As long as he's got $1,000, he's going to get out. And so the public safety is augmented if this person is released with the condition of mental health treatment. And so that's the way it works in Bexar County. If you're released, you're under pretrial supervision. And one of the conditions of your bond is you have to cooperate with the mental health treatment. You have to show up at your appointments. And so in the first year, we were looking at how we're doing as far as compliance. So for the first year, and actually this is probably our numbers for the first couple of years, 25% of the people that we represented at magistration failed to comply. 75% of their cases, though, were closed satisfactorily. And what does that mean? Their pretrial supervision closed satisfactorily. They showed up at all their court appearances, they maintained their pretrial appointments, and they maintained their treatment. And actually, treatment compliance was even higher. So for the clients that we referred to treatment as part of this program, 91% remained engaged in treatment throughout the entire pendency of their case. For the clients that we didn't represent, only 79% were compliant with treatment. And so when I say the clients we represented versus the ones we didn't, we started this program in 2015 with a grant from the Texas Indigent Defense Commission, and it funded 3 attorneys. And in Bexar County, like Harris County and like some of the bigger counties, we run 24/7 magistrations. And so basically when people are arrested, they're brought in 24 hours a day. And depending on how many people are being arrested, you could do 10 magistrations in a day, or 5, or 20. And so we magistrate about 60,000 people a year in Bexar County. And because we only had 3 attorneys, we were able to provide Monday through Friday 24-hour coverage. We worked 3 shifts, 7 to 3, 3 to 11, and 11 to 7. Friday and Saturday, we didn't staff it. So that's what we were doing. We were comparing whoever we represented during the week versus the people we didn't get to represent on the weekend. And when we saw that, again, the people who had an attorney there to guide them through the system did better. Because that bond was still available on the weekends and the judges could order it. The difference was there was no attorney there to explain what was going on, to talk to the people about, okay, do you want to do this program? Because we actually have some people who say, no, I would rather pay $1,000 and get out. I don't have to do this treatment. I don't want this treatment. But I think the biggest difference is what we see is how many people do want the treatment. Because when we started, I was afraid of malingering. I thought, okay, a lot of people are going to see this as an opportunity to get out of jail for free. And they're going to take advantage of it. It seemed like it was just the opposite. There's such a stigma with mental illness. Even people that we knew had been treated for mental illnesses before, because we had access to the CCQ inquiry and things like that, they would deny any mental health issues. It's such a stigma, people didn't want to admit it, even if it gave them the opportunity to get treatment. Now, what we've seen is the county has really stepped up and supported this. Our grant started in 2015. It ran out in 2019, this year. But the county has really stepped up because they've seen the benefits of diverting people and how many people we are diverting from the jail. When we started, we had 3 clinicians, and the clinicians are the persons provided by the mental health authority to do these assessments, and 3 public defenders. Now we have 9 clinicians and 9 public defenders. The county has not only kept the program going, but has greatly expanded it because we are able to divert so many people from the system. We're talking about providing counsel at magistration, and the current state of the law is that you do not have to provide counsel. However, I can tell you that as part of a lot of the federal litigation that's going on right now, it does sound like that's going to change. And so I say that to you so you in your jurisdictions are probably going to have to be thinking about some way to provide counsel to indigent persons at magistration. And that's another thing that us getting into this program did. It made our judges and our DA think about magistration. Because it has kind of become in the past to just be this perfunctory exercise. It was basically, oh, you're going to bring them in, you're going to read them a script, you're going to set their bond, usually off a bond schedule, and then you're going to shuttle them off to jail, where they'll wait for the judge to call them to court. And what the litigation that's going on, primarily in Galveston County, is saying is, wait a minute, that first hearing when bond is set, that's a critical stage according to the Sixth Amendment. And if it's a critical stage, you are required to provide counsel. Now, this is the language from the order on the temporary injunction in Galveston. To conclude, the court finds that Booth, the plaintiff, has adequately established a likelihood to prevail under the Sixth Amendment, since the Constitution requires representation by counsel at the initial bail setting hearing. Now, if that goes on and becomes the final decision of the judge in Galveston and it goes up to the Fifth Circuit as an upheld, guess what? The 1517 is now a critical stage. And if it's a critical stage, each county is going to have to figure out a way to provide representation at that first hearing. And so what we were able to do with the representation of the mentally ill, we've been expanding on that, and our office now provides representation to everybody who comes through at the 1517. We'll go to the next one. So how do you start? I mean, it feels like a monumental task. I can tell you that when we started. And I can tell you every jurisdiction is different. And I know these are all urban jurisdictions. The first step is figure out how you're doing magistration. A lot of people don't know. A lot of the stakeholders in your county don't really know. Remember, 1517 says that the law enforcement officer who makes the arrest has 48 hours to take that person before a county magistrate. That's happening, and a lot of times you don't know. It's law enforcement who knows. So that's how that conversation begins. If you're like us or like Dallas or Harris County, you have a centralized system where everybody gets brought to the same place. But in some of the moderate-sized counties, maybe you have JPs doing the 1517. Usually what I've seen when I practiced in Cameron County was they would do magistrations once a day. You know, everybody who got arrested in the last 24 hours is going to be magistrated the next morning at 7 a.m. So there's different ways you could do this in your jurisdiction. It's more challenging for us because, again, it's at 24/7. It's like we have to staff an emergency room or a fire station because there may be times when nobody comes in, but we have to be there just in case. But if you know that your magistrations are once a day, you could do some type of an attorney of the day system. Again, going back to Cameron County, they are providing representation at magistration now at their once-a-day hearings, and they basically appoint an attorney off the wheel to be the attorney of the day to handle all those magistrations. You can also look at what resources do you have right now. I mean, If your county has a local mental health authority, which you do, what services are they currently providing? If you look at the bench book that was passed out, it talks about what services the local mental health authority is required to provide. So without anything extra, without any differences, they're required to provide certain services right now. One, they have to provide a 24-hour crisis hotline. And that's a hotline you could use for the people at magistration. They're also required to provide the examinations to comply with 1622, which is the Sandra Bland Act. They're also required to do the examinations, if ordered for the magistrate, for the 17032, the special mental health treatment bonds. So those services are currently there in your county. It's getting everybody on the same page as to how to utilize those. Now, you can also do what we had done in Bexar County, which you can negotiate some type of agreement to get your people into treatment, because that's the other component of 17032. It's not just the evaluation, not just knowing that someone has a mental illness, it's having a treatment plan in place. But the biggest thing, too, is bring everybody together, get everybody on the same page. And, you know, I'll speak to the judges. You're the leaders in criminal justice, and so everybody listens to you. If I call a meeting, people may or may not show up. But if you guys call a meeting, I guarantee you everybody will be there. And so you could just start by saying, we are going to look at magistration and look at what we're doing with it now and how we can do it differently. Also, what we do is we either have specially trained attorneys on our mental health appointment wheel, or we assign them to our office, the public defender's office, in our mental health felony and misdemeanor divisions. And so being there at magistration, it also allows our attorney to work with pretrial services and the judges to direct those persons who are going to be appointed to someone who knows how to handle a client who has a mental illness. So really, the attorney you have there at magistration is acting as kind of a air traffic controller who is finding this person and trying to get them in the right kind of treatment. If you think about the judge is impartial, right? The judge isn't supposed to be making a decision. So about the person. He can't call family, he can't talk to them, he can't interview them. It's supposed to be impartial. So that's what our attorneys do. If we get a client in who tells us, you know, I've got a job, we can call and speak to their employer. Hey, you know, mom said I can come back home. She's not that mad at me. So we can call mom and verify, yeah, judge, mom said he can come back home if you'll just grant him a PR bond. But the biggest thing is we see people highly motivated for treatment. We see people who don't have health insurance, who don't know where to go, who may be on the waiting list for treatment somewhere, but they're excited about the chance to finally get their situation addressed. The challenges are not insurmountable to provide counsel at magistration, but I can tell you it's going to have a huge impact. And when you hear the word diversion, this is that second opportunity to divert someone. The officer's made his first decision. Now we have people who the officer is going to take to jail. What are you going to do with them differently? I'd be glad to answer any questions if anybody has any questions. Yes, ma'am.
Yeah, I have a question. Can you talk about the 17032 language as a mandate shall release? But my question is about the language in that same section about unless good cause is shown otherwise. Have you not found that that includes mandate?
It is. The question was, if you read 17032, it says that the court shall release on a PR bond if you have a diagnosis of mental illness and if you have a treatment plan. And she just pointed out that it also goes on to say, unless good cause is shown not to. And again, that's each judge's proclivities. I mean, we had some judges at magistration who were very reticent to grant these mental health PR bonds. Even when we had the DA agreeing that it was appropriate. That's the one that always got me. The The public defender said, Judge, this person needs a mental health PR bond. The state said, yes, Judge, this person needs a mental health PR bond. And the judge would deny it. Again, that's just part of, making sure everybody understands. But yeah, it is an out if the judge doesn't want to. Even if you tick off all the boxes, the judge can still deny it.
And then my second question, if I can ask is, that you mentioned that y'all have access to CCQ data. Do y'all have direct access? Does somebody have to print that out?
Yeah, we do not have direct access. Her question was, does our Office of Public Defenders have direct access to the CCQ data? And if anybody's unfamiliar with it, CCQ stands for Continuity of Care Query. And it's basically part of a database that's maintained by Texas Department of Public Safety. And so it's similar to the TCIC, NCIC criminal histories. And what that database will tell you is if that person has ever been connected with mental health services in the state of Texas in the past. And so that's one of the screenings we use to determine if someone has a mental illness. The first one is law enforcement will ask them questions, and those are apparent on the booking slip. The second is we'll have someone from pretrial run the CCQ for us. And then the third, 1622, the Sandra Bland Act now mandates a jail questionnaire that the sheriff has to provide before someone is booked in. And so one of those three will usually signal us if someone has a mental health issue. That answer your question? Any other questions from anybody else about what we're doing? Oh, yes, sir.
Did you work with the Mental Health Authority to train, I'm sorry, thank you. Did you work with the Mental Health Authority to train those public defenders on working with that population specifically, or how did you go about navigating that and selecting the right public defenders?
Oh, that's a great point. Our public defenders have undergone training with our mental health department and the clinicians. I mean, our people who do the mental health are focused on, one, how to communicate with someone who has a mental illness, and also they need to know about all the services. We work extensively in County Court 12 with Judge Huff. She's here today. And through that, we learn about all the different programs and all the different things that are offered for these types of diversions. So, yeah. If there's nothing else, I'll be available anytime. Next slide should have my contact information, including my cell number. I'd be glad to answer anyone's questions anytime about what we're doing. And of course, anyone come visit. We visited Harris County and saw their system. You're welcome to come see ours as well. We're always open to sharing what we're doing. Thank you all.